During week 2 of Legal Aspects of Media, we developed a more in-depth focus on defamation, including libel and slander, and I will focus specifically on 2 renowned cases, namely New York Times versus Sullivan and Gertz versus Welch. During this course, we learned exactly what defamation is. And the dictionary definition of defamation is as follows, quote, the act of communicating false statements about a person that injure the reputation of that person. The first case I'm going to examine is New York Times versus Sullivan, which was argued in January 1964 and decided 2 months later on March 9th. Sullivan, who was the plaintiff, consulted legal action after he felt as though he had been libeled by the New York Times. The news source had run an advertisement that turned out to be quite problematic. Sullivan was one of 3 public officials in Montgomery, Alabama, to state that the advertisement defamed him. He felt as though his reputation was damaged because he was responsible for the direct oversight of the police. In one of the paragraphs of the ad mentions the police were ordered to lock the cafeteria at Alabama State to starve student protesters. The defendant stated that it had no reason to believe any of the contents of the ad were false, though they were puzzled how it defamed Sullivan without mentioning his name. This was a case of libel specifically, which is the written defamation of a person's character via publication or any other variation of publicized writing. Because Sullivan was a public official, he and his legal team had to prove, quote, that actual intent to harm or recklessness had to be found before punitive damages could be awarded, or that a verdict for respondent should differentiate between compensatory and punitive damages. After reviewing the evidence, the jury decided that the advertisement was, quote, libelous per se, unquote, but there was no unequivocal evidence to support the ad ran with malicious intent. Regardless, this resulted in Sullivan. He was granted $500,000 in damages. The next case I will be discussing is Gertz versus Welch, which was presented in court in 1973 and was brought to a decision in June 1974. The parties involved in this case are Gertz, who was the attorney in a murder case against Nuccio, a Chicago policeman who was charged with the crime. Welch was a magazine professional that ran a publication in which Gertz's case was described as a communist conspiracy to frame Nuccio for the murder and subsequently discredit the police in Chicago. Welch made an unproved implication that Gertz had a criminal record. Gertz, as a private individual, was involved in a situation that had implications for public concern because the allegations against him proposed a communist conspiracy. Welch's team had to prove that the claims they made against Gertz were accurate. However, Gertz had to prove that Welch published the American opinion issue in actual malice, meaning to purposefully impact his career and reputation. I think these allegations negatively affected his reputation. Welch claimed his criminal record was so large it took a very strong officer to even lift the file. This is obviously problematic for a practicing lawyer. Furthermore, communism has never been a political party that was accepted with open arms in America. In fact, it is rejected more often than not. These are serious accusations. With Welch's blatant disregard for the truth, I do believe that he did it maliciously to further his own agenda. There is one main thing I would have told myself if I had been in Welch's shoes decades ago. I would have done more research and had something to back up my accusations. No matter what, you know, or you can at least safely assume someone will take you to court over accusations like these. Welch should have prepared more for this or not run the issue at all. Each state can have its own variation of defamation and how it handles each unique case. I live in Pennsylvania, so I will take a closer look at my state's defamation laws. Even though this state is has very similar laws to those governing our nation as a whole, there are a few differing qualities. In regard to malice and negligence, Pennsylvania law states that there must be evidence supporting the defendant committed the defamation with actual malice or, at the very least, handled the information negligently. The law also splits individuals into separate groups. The private figures would be a dentist or a private party host or hostess whose neighbors complained to the newspaper about the noise. A limited purpose public official would be locally renowned individuals who were featured in the news or magazines, or engineers or architects working on controversial and scandalous public building projects. All purpose public officials include police officers, public school teachers, and politicians. There is a statute of limitation for defamation in Pennsylvania. People have 1 year to seek legal justice. I feel as though these cases are important to learn no matter what field you are going to. I cannot think of any career that is not vulnerable to a lawsuit. Having said that, this assignment and our class discussions make me all the more aware of just how vulnerable individuals can be. Without even thinking, we have committed a crime by venting to someone on Twitter, or, in the case of Sullivan, someone tried to make a political statement and it tanked. Now we are being sued over one error. These lessons prompt me to be more careful about what I say and write. You never know who will take offense to what you put out in the world for the world to hear and read. That simple reminder is what I will take from this class.